Okay, let's go ahead and get started. We have a few more people who will be joining us here on Zoom, and welcome to all those who are joining us on Zoom, to those that are watching live on YouTube, and to everybody who will watch this recording in the days and weeks ahead. My name is Miles Hanson. I'm the president and CEO of World Trade Center Utah, and we're very, very grateful today to Parsons Behle Latimer, the Chapter 11 Bankruptcy Group, for joining us to talk about bankruptcy. It's a difficult topic, but in today's economy, it's one that needs to be addressed. We are seeing a wave of bankruptcies rippling across the United States, and it's a trend that's happening around the world. And so what we want to talk about today is how Utah companies can sustain their global supply chains during what may be a bankruptcy tsunami. We don't want to be doom and gloom. We don't want to focus on the negative, but we want to be realistic about the challenges that bankruptcy can present, as well as thinking through what are those steps that you can take as a business if somebody that you are working with lets you know that they're going to be moving forward with a Chapter 11 bankruptcy. I think it's very important to help emphasize the depth of expertise that we have on the call today. Parsons Behle Latimer's Chapter 11 Bankruptcy Practice Group has extensive knowledge and experience in bankruptcy and adversarial state and federal courts. The firm works with clients to protect and preserve their interests to the fullest extent possible. And so what you see is everybody that you're hearing from today in the practice group have deep experience, both with Parsons Behle Latimer, but also other firms that they worked at before, as well as working in court, clerking for federal judges on this issue. And so you could not get better expertise than we're going to get today. And so we're very, very grateful. Mike Bailey, who is a board member of World Trade Center Utah and a partner at Parsons Behle Latimer. Thank you, Mike, to you and your team for lining this up. Thank you to Jason Castor, who is a great partner of ours in lining up these webinars. I think this is the third or the fourth webinar that we've done together over the past few months, all of them providing very important content that has been very beneficial to our Utah companies. And a special thanks to Tom Beckett and Bruce White for being with us and sharing your expertise today. And so with that, Mike, I'll pass the baton over to you to kick this off with a final reminder to everybody who's joining us live right now in Zoom. This is a focused topic. It's one that's deep, that requires a lot of expertise. There can be a lot of case-specific information. And so we wanted to keep this focused to create an opportunity to have plenty of time to discuss. So please don't be shy. Use the chat function, use the Q&A function. Once we hear from Tom and Bruce, we'll have an opportunity to spend some time in a discussion. And we should all just imagine that we're sitting around a boardroom around a table together, having a discussion, just doing it virtually. And so please think about your questions. Don't hesitate to ask anything that may be specific to you, or you can always ask for a friend if that's a little bit easier for you. So with that introduction, Mike, I'll hand it over to you. And again, with a great deal of gratitude for your partnership, your support and participation in World Trade Center Utah, and your work lining this up today.
Miles, thank you so much for a great kickoff, as usual. I would be remiss if I did not thank the World Trade Center Utah and you specifically for the opportunity on behalf of Tom and Bruce and the law firm of Parsons Behle Latimer for being able to present today's topic. World Trade Center Utah has been an incredible partner for Parsons Behle Latimer, and we could not ask for a better partner during this pandemic. And so thanks for the opportunity and thanks for everything that you do, Miles. Today, as everybody knows, we're going to be talking about sustaining global supply chains in a bankruptcy tsunami. And we have two presenters, Bruce White and Tom Beckett, two of the very best bankruptcy practitioners, if not in the nation, certainly in the Western United States. And we're so fortunate to have them at Parsons Behle Latimer. I'll introduce them briefly. Tom has a JD and an MBA from New York University. He is the head of the bankruptcy group at Parsons Behle Latimer, and he is a certified business dispute mediator. Bruce White is on the board of directors of Parsons Behle Latimer, where he serves as vice president. He has over 25 years of business experience in the corporate and business areas. And as Miles told you, both of these gentlemen have practiced in major law firms in other cities. And importantly, both have gone through a downturn or two where they have had the opportunity to counsel clients just the same as they will be talking today. So, and before we get started, I need to tell you, as we always do, that this is not legal advice today. This is merely a presentation. And if you are in need of legal advice, feel free to consult an attorney. Do not make any business decisions entirely reliant upon the advice or the discussion today. And if you have any further questions, please reach out to Bruce White or Tom Beckett. And with that, I'm going to turn the time over to Tom Beckett.
Thanks very much, Mike. Greetings, everyone. Thank you for participating. I'm going to ask if you have questions during the course of the presentation, please feel free to chat them to Mike Bailey, and he will interrupt Bruce and me and forward those questions. We would like to hear from you. I want to begin with a question, something that's been bothering me, and it may be bothering you. So, where are all of the bankruptcies? Yes, we've seen some, and we've seen some fairly high-profile ones. I think many of those entities probably would have filed this year even without a pandemic. But I'll show you in a minute, an interesting phenomenon here is that whereas in the Great Recession 12, 15 years ago, the market crash accelerated the filing of bankruptcies, in the pandemic recession, they've actually de-accelerated the rate of filings. I don't suppose that's because a pandemic is good for business and therefore there are fewer bankruptcies. But I think it indicates that there's a heck of a backlog of bankruptcies that will be filed eventually. And there's kind of a logjam. We can talk about some of the reasons for that. But when the logjam breaks, there will be a wave of business bankruptcies. And for purposes today, when I say, and when Bruce talks about business bankruptcies, unless we're talking specifically about Chapter 11 reorganizations, don't think about workouts, reorganizations, and happy endings. Think about business failures, okay? The larger the number of bankruptcies that are filed, the larger the number of business failures. And there will be three consequences of that. One is that businesses that have customers who fail will see their income fall. Businesses that have suppliers fail will suffer supply chain interruptions and disruption. And there will be a glut of assets for sale. And that's one opportunity in the midst of this that I want you to keep in mind. There will be a lot of stuff for sale. So here's what we have planned. I want to do about 10 minutes of a slideshow on economics and bankruptcy trends. And then Bruce and I are going to swap off talking about bankruptcy and insolvency issues. And I think the purpose of this is to refresh your recollection and sort of increase your bankruptcy awareness so that when we get into this in the next few months, you'll know what to think about. So I'm going to share. Bear with me for a moment. Nope.
Oh, you had it.
I had the email, Bruce. I didn't have the presentation, did I? There it is.
There it is, Tom.
Thank you. Let's start out with a brief walk back through time. This is using data from the Weekly Economic Index, which is published every week by the New York Fed, and go back to the Great Recession. I'll remind you of what happened then the market crashed in March of 2009, and bankruptcy filings peaked 2 months later. It took another year for the number of pending active bankruptcy cases to peak, and it took 10 years for all of those cases to run through the system. What I want to show you here is compare the depth and length of the Great Recession with the pandemic recession. Can you see that behind the photos? If you can't, I don't know what to do. Can I move your photos and look at the depth of the pandemic recession? This is intended to mimic GDP, and it shows 4% in 2009, and we hope we've bottomed at 12% currently. So it is sharper and deeper. I want to just point out a couple of these statistics. Everyone knows that unemployment has gone through the roof, upper left. Lower left, consumer sentiment, of course, went down. Concerningly, it went down, it went up, and then it went down again. We don't have the numbers for August, and we won't have them for another month. Personal spending went down, savings went up. The personal spending is what economists are going to be watching for to see if we have a V recovery or a swoosh recovery or a K or a W or whatever it's going to be. It's going to be largely a function of consumer spending. Consumer spending is about 2/3 of GDP. Let's look at these four. There's concerning information here. All loans, commercial banks, upper left, you see they started back up after going down for a year. They started back up in Q1 2020 and up again in Q2. Delinquency rates of credit cards then took a dive in Q2. And the reason for that is that credit card companies are giving out forbearances like candy. Because if they give a forbearance, they don't have to put the account in delinquency status. Lower left, you see consumer loans, not including mortgages. That also has taken a dive. And the reason for that is the credit card effect and the forbearances that have been granted under the CARES Act for student loans, which means that everybody had enough money to pay their auto loans, which is the third major component of consumer loans. So that went down as well. Notwithstanding all of that, and I find this alarming, notwithstanding all of that, and the forbearances granted on single-family mortgages, that number has begun to go up, and watch for it to go up a lot in Q3. In the energy sector, West Texas crude was fairly stable at around $60 and then took a hit. I think there was a war between the UAE and the Russians. There was one day in April where actually theoretically you'd have to pay somebody to take the barrel of oil off your hands. It has restabilized, but look, it's restabilized at $40 a barrel, and the spread between 40 and 60 is the death warrant of a lot of companies. So in the face of pretty bad economic news, let's see what happened with business bankruptcy filings.
Hey, Tom, if you go back, Tom, go back one slide for just a moment. You know, I think what's interesting to point out with regard to the slide on supply of oil and price of oil at WTI, keep in mind in Utah, the crude that comes out of the Uinta Basin is at a differential between $10 and $15. So if WTI is at $40, the folks in the Uinta Basin are selling it for $10 or $15 less. And at that price, you can see why the Uinta Basin for a great amount is just basically shut in.
Understood, thank you. The wavy lines at the top of this graph are the last 3 years of business bankruptcy filings. The blue bars running along the bottom are this year by month. So you see there was a spike in January, and that was largely in Texas and Delaware. And then February and March were kind of low. April was very low. There has been a slow progression back since then, but even through July, business bankruptcy filings remain below the historical 3-year level. Now, I will tell you, August numbers, I was hoping to have them this morning. 15 minutes ago, they hadn't been published. I hope to have them this afternoon or tomorrow. Before we send you the deck, and I have a larger deck with more information, give me 24 hours to update that, because we'll have August numbers. And, you know, I can't sleep. I want to see whether August remains low or whether August has gone high. When we correlate COVID cases here with business bankruptcies per month, the Dow correction was late February, early March, and bankruptcies fell. Now, remember, from the Great Recession, we would have expected to see them then rise within 2 months, and it's been 6 months, and there's been no appreciable move. We'll see what happens in August. COVID cases went up here, bankruptcies went down. COVID cases went down, bankruptcy went up. In this period of time, until, well, through June, there was a negative correlation between COVID and business bankruptcies. Consumer bankruptcies and foreclosures fell off the map in the second quarter. Taking a look at the components of bankruptcies, Chapter 7s fell, Chapter 13s fell hugely. What I'm including are Chapter 13s that have a business component, not all Chapter 13s. The fall in consumer bankruptcies in Chapter 13 was precipitous. That's reflected in those that have a business component. These are sole proprietorships, but they're a fairly significant aspect of the economy. Chapter 11s, you see, may have gone up a little bit. Now, your Chapter 11 is the reorganization. Chapter 7 is liquidation. Chapter 11s look like they went up a little bit. When we look at that compared again to the last 3 years, what we see is higher in January. That had nothing to do with COVID, and typical in February and March, April. May, June, and July have been high, but they haven't, you know, the last time they were this high was 2013. And while remember the financial turmoil of 2013, I'm being facetious, nothing happened then. That was still the runoff from the bankruptcies pending from the Great Recession. And so then nothing here yet is beginning to look like a spike. How about our 4 most populous states? California, lower than 3 years. New York, lower than the last 3 years. Florida, same. Texas is kind of in the midst of it. It's a pretty typical year in Texas. Texas has big numbers because in January, a company filed bankruptcy and they had about 300 subsidiaries. So that skews that number. Otherwise, what we're seeing is fairly typical and ordinary. The heat map here is pretty incredible. Had I thought about it, I wouldn't have made it red and blue, but the red states, sorry, are those where bankruptcies have increased year to date through the end of July. Here's the list. Delaware, North Dakota, Mississippi, Texas, Alabama, Alaska, West Virginia. West Virginia is up by 1%. So look at what that means. It means you have 7 states that have more bankruptcies this year than year to date last year. And that means you have 43 that have fewer. And you'll see Utah right up there at number 3. I think it's 37% down. We'll see how that changes in August. I took a look at the regional. There's a big bump in March. That's typical. that has to do with Chapter 13 filers who want to protect their tax refunds. Otherwise, pretty normal. Montana is down, Idaho is flat, Colorado's flat, Nevada's down, Arizona's down, New Mexico going up. I think Utah and Wyoming show some increase, but these are pretty low numbers to add to the mix. So again, overall, what I'm trying to say is there has not yet been a spike. That means there's a backlog, and we can expect bankruptcies to form a wave or tsunami. So why? Well, there was $2 trillion that went into the economy under the CARES Act, and that kept a lot of people afloat. The Federal Reserve did a good job of keeping borrowing rates low and keeping the credit markets open, and they had slammed shut in the Great Recession. State and federal moratoria on evictions and foreclosures, for the most part, the federal moratoria have been continued now through the end of the year. But that's only with respect to, on mortgages, that's only with respect to federally guaranteed mortgages. That's about 60% of single family residences. The other 40% are not bound by any moratorium, except maybe in New York and California. Otherwise, they're free to commence foreclosures, but they're holding off. Now, when one of these four big banks decides that they're going to start closing, then the other three will quickly jump in, and it'll be a bit of a mess. The HEROES Act, I know it didn't pass, but it raised expectations for another trillion or $2 trillion in support. Home values, unlike in the Great Recession, where home values cratered, home values have held well in the pandemic recession, meaning that people have equity in their houses to draw from for current expenses. Remember, delinquent is not delinquent until it's 3 months delinquent. And so, you've got delinquency, and then you've got warnings and notices, and then maybe a court proceeding, and then maybe something happens. It might take 3 months for that to run through the system. Our court system now is a bit backed up, and criminal cases are going to have priority. That delay is going to last longer. Secured creditor and debtor reticence. Now, suppose you're a secured lender and your loan is secured by a fleet of luxury boats, ships that take people to sea, or at least used to. You might not want to foreclose on that collateral right now, because who would you sell it to? So you're not going to start the foreclosure, and that's not going to force the debtor into bankruptcy. From the debtor's perspective, maybe they would want to go in bankruptcy because they'd want to have what we call a 363 sale and sell the bank's collateral. But who's their buyer going to be? So they're not going to be anxious to file bankruptcy right now either. Finally, there's uncertainty. I mean, to file bankruptcy, you really need to know one of two things. Either there is no hope and your company is not going to survive, or there is hope and you know how the company is going to survive. These are very uncertain times, as they say, and so people don't know, and they don't have the certainty, I think, to push the button and file bankruptcy.
Hey, Tom, sorry about that. I'm getting some sort of feedback. Just want to put an emphasis on the CARES Act and the role in likely delaying bankruptcies. Here, especially here in the state of Utah, Utah led the country in terms of utilization of the Paycheck Protection Program. Here in the state, I believe that 95% of eligible payroll ended up being covered by a paycheck protection loan. So for those that I think most people on the call today are familiar, loans that were designed to help companies stay afloat during the pandemic, this uncertainty. Well, originally the loans were designed to cover a period of a couple months, about 60 days. Congress extended that so that companies could use them for 120 days. We'll be coming up on the end of that 120-day period here, I believe, for a lot of companies towards the end of September. And so just adding an emphasis that the policy was designed to be a bridge across the economic consequences of the pandemic. we'll be nearing the end of that bridge here pretty soon. And that's why there's a lot of urgency in saying, let's get the economy bouncing back so that you don't have as many people going off of the end of that bridge, if you will, before it's completed. And so that, I imagine, has had a significant effect in helping companies weather the storm, stay in business, not have to go through the bankruptcy process. But if Congress does not pass additional extensions of the program or whatnot, then we've got the end of the bridge coming up here at the end of September or so, and it's not exactly certain for which companies the bridge is going to be long enough to get them where they're going to be able to thrive. And so my guess is, especially here in Utah and other states that utilize the program, that has been a significant factor in delaying.
Absolutely.
And a very positive story, right? That shows us the program's working as intended. The question is, what comes after the end of September? Does Congress act again? What happens with the economy? And that's where my guess is you're going to have a lot of companies over the next few weeks really taking a hard look at bankruptcy and what that could mean for them or the companies they're working with here in the U.S. or elsewhere in the world.
Yeah, Miles, you hit it right on the head. The AAA, or excuse me, the PPP loans have really helped businesses. There's sectors, though, and quite frankly, the money is running out from those sectors. And so if you're in a sector like restaurants or to movie theaters, it's pretty tough right now because you're running out of the PPP money and you are, your business isn't back. Restaurants are half full at best. And so there's it's delayed those filings to a great degree, which is exactly what the PPP loan was set to do, but it's running off. And so what's going to happen at this point when businesses aren't fully open and business hasn't come out? Now, and really what's interesting is Utah's in a great spot from the standpoint that employment is back and business is back to a great degree, not fully. But if you're doing business out of state, we can guarantee you, even if your business is doing well, you're going to have customers that are going to file bankruptcy. And you're going to have some issues that way. And so I want to give some practical advice with those types of issues. And so let's say, for instance, you're supplying goods or services to other companies and you have other companies that you can see that they're starting to struggle. How do you see that? Their ARs are stretching out. Days from invoice to payment are stretching, and you're not getting the cash in. And so the first piece of advice I would give is be proactive. Be proactive. If you sit back and let your AR stretch out, you're going to be in a hurt in a couple of ways. And we'll talk about that in a minute. But be proactive. Some ways to be proactive. If you've got a customer that's stretching you out, cut them off sooner. Put them on COD. The way to keep your cash and make sure that it doesn't get clawed back in the bankruptcy process, which we will talk about, which is called a preference action, is put them on COD. And until they can show you that they can earn that credit back. That's one way to protect yourself. The other is, shorter terms. Document those shorter terms, though, so that everyone agrees that, look, this is the payment course that you're on. From a supply chain standpoint, we're going to see interruptions in the supply chain, particularly with regard to vendors being stretched out over time. And so be proactive, watch your ARs, be in contact. If you have another key component is if you have a customer that isn't paying you and they're not talking to you, that's a red flag. They should be talking to you. And they should be explaining to you, hey, look, this is the position we're in. They should come to you with a business plan and say, this is how we can pay you. This is how we can work it out. If they don't have a business plan, it's another red flag. They don't have a plan to work out of this problem. know what your documents say, know what your documents call for. If you've got purchase orders, you've got terms and conditions to those purchase orders, are you following those terms? Or are you just letting them run with them? That becomes important again when it comes to the preference action issues in a bankruptcy. Also, when you talk about contracts, one big thing that's occurred during these last 6 months is, do I have to perform under my contract? Or does the quote unquote force majeure provision in the contract let me get out of performance under the contract? Those become very technical issues. And even if your contract doesn't have a force majeure provision in the contract, there is law in most states that would allow a vendor or a supplier, if it is impossible to perform, to get out of that contract. So knowing those types of provisions in your contracts become very, very important. And just knowing what you can and can't do, particularly in and out of bankruptcy. So be proactive, know what your contract says, watch for those red flag signs when you're dealing with your suppliers or with your customers. Tom?
Bruce, you mentioned a good unemployment picture in Utah. I think Utah has the highest employment rate in the country. So you take Bruce's advice and stay ahead of the problem. But what happens if you have to take action? I guess there are 3 arenas you can do that. One is private. You can negotiate or mediate. Let me come back to that. The second is file a lawsuit in state court. Problem is, state courts are clogged up, and as I said, they're giving preference to criminal actions. You may make an impression on someone by suing them for an account, but it's going to take a long time to collect. Don't get your hopes up. Federal court poses the same problem. In terms of filing a lawsuit to collect, you may be thinking about filing an involuntary bankruptcy. And tell me if you disagree, Bruce, but I would say my advice on this is do not file an involuntary bankruptcy to collect money. That's not how it's going to work out, and it's going to take forever. If you think that the account debtor had assets last month, and now for some reason they seem to have gone away, then you very much might want to have an involuntary filed so that you can have a trustee who can look to see where the money went, right?
Yeah, I would totally agree with that, Tom. I think if you're filing an involuntary, you're basically saying, I am not going to collect this, and I believe that there's been fraud, and I want somebody to investigate that fraud. If you think the involuntary is going to help you get paid, we can show you a lot of statistics that say absolutely that's not going to happen. But it is a way to hold management or owners accountable if there's been fraud.
Now, going back to then the private arena and how do you collect the debt, it's a matter of negotiation. And as Bruce said, you got to know your side of the story, and you got to require them to know their side of the story to have an effective negotiation. As a mediator, I'll give a mediation plug here. Ask, if you can't negotiate something pretty quickly, ask them if they will sit down with a mediator and go through a process. If they agree, I will tell you that agreeing to mediation is about 50% of agreeing to a settlement. Okay, you're taking that step, you're undertaking to sit down and work it out. Sit down with somebody for an afternoon and try and get an agreement. And when you do the mediation, you got to be honest with the other side. They've got to be honest with you. You've got, a cool head in the room who can say, well, you're asking for too much, or this is, you're not appreciating what they just said. Try that. Bruce mentioned clawbacks, and I'll try and do this quickly. It's a term of art. There are kind of 2 clawbacks that we think about. One is the preference, and the other is the fraudulent transfer. Let me do preference first. If you are a seller of widgets and you have a customer who is way behind on paying you for her widgets, and then she starts to make up and she starts to make payments and you improve your position and you're getting to 75%, and then she files bankruptcy. Okay, then you find out that the other creditors were getting 10 cents. Okay, none of them got the 75 cents that you got. You were preferred, and the trustee wants to take the money back from you, add it to the estate, and distribute it fairly among all. You have a couple of defenses. One is ordinary course, and you say, well, you know, I don't think my hypothetical fits, but well, however you were paid in 90 days, you say that's how they always paid. And that's the standard in the industry. That's how they always pay. That's how we always act. It's ordinary course. That's a defense. The other is called the new value exception. She pays you for a widget from a year ago, and you send her a new widget. You know, you're not, and you haven't put her on COD, and so you're not going to get paid on that. And then she pays you for another widget, and then you send her another widget. You've added new value, and you're entitled to an offset. One thing I want you to keep in mind on preferences especially is you're familiar with the letters that you get from a bankruptcy trustee, and the trustee says, you know, I'm a court appointed trustee or whatever, I'm in this bankruptcy case, and we see that you were paid $1 million in the 90 days before the bankruptcy. Send us a check for $10,000 and we'll forget about it. And know what your defenses are. If you have a good defense, then you can either ignore the letter or write one back that's a little testy, because Congress changed the bankruptcy code this spring to require trustees, this is not before they send a letter, but before they file a lawsuit against you, they have to have investigated your defenses. And a real quick story, in a big bankruptcy case called Sears, we had a client that had been paid almost $700,000 in the 90 days before the bankruptcy, and the trustee just simply sued the client. And the response was, well, you didn't investigate our defenses because we have a good new value defense. And the answer is, well, we don't think much of your defense. And the response was, you can't file a lawsuit until you investigate our defenses. Dismiss your lawsuit. And after going back and forth a couple of times, they dismissed it with prejudice and went away. So remember that part of the code, it's important. Fraudulent transfers are another thing that a trustee may come after you for. You know, I mean, I think the archetypal description of that is I'm backing out of my driveway one morning and I'm not paying attention and I run over 3 people and I think, oh gosh, I'm going to be liable. So I drive back into my house, run upstairs and assign my interest in our house to my wife for $1. Okay, now I'm judgment proof, right? I don't have a house. I don't have anything. That's a fraudulent transfer. You did that to keep your creditors from getting your money. In the real world, it comes up in different circumstances than that. It is that, you know, you bought a gold mine and you got it for a really good price. And it was a really good price because it was really risky. But you paid very little for a gold mine and it turned out to be worth a lot. And the seller files bankruptcy and the trustee comes back after you and says, you didn't pay enough. You have to now pay, come up with reasonably equivalent value for the gold mine or give it back to us. So you're going to have to go back and recollect what was happening then and say, no, I got the short end of the stick. I took a huge risk. It happened to pay off, but I probably overpaid for this thing. What we're telling people now is when you buy assets in an environment like this, and you are not paying as much as you might have paid 6 months ago, do a memo to the file that includes every consideration why you got the short end of the stick. It wasn't a fraudulent transfer. You didn't steal these assets. You probably overpaid for them. And then you have that contemporaneous evidence to present to the trustee to fend off the fraudulent transfer. Comments on that, Bruce?
Yeah, fraudulent transfer is a very unique issue that is very fact driven, and you really have to document the evidence of value at the time of the transaction. And you know, if you can do, if you have evidence of value, just as Tom stated, you got to make sure you document that. I want to go back just a moment, Tom, and talk about preferences a little bit more. One thing that you need to know is every bankruptcy case produces these preference actions. And as creditors, we hate preference actions because here you've lent money to a company, they're supposed to be paying you back and they pay you half of it. And then you get a letter where they want to claw it back from you. And you just think that is absolutely unfair. And so as part of watching your ARs and making sure that you keep in terms goes to this preference action. If you are outside of the ordinary course of your business or your business terms in your terms and conditions, that's where you have a problem. So I can guarantee you, if you are selling product or services to retailers, to oil and gas companies, to anyone that's really been impacted, restaurants, anyone that's been impacted by COVID and has filed bankruptcy, you've got preference exposure. And so you may want to be proactive and do your analysis now and say, okay, look, JCPenney's filed bankruptcy. They're going to be sending tons of these actions out. If I did business with JCPenney's, I would want to know what my exposure is. Quite frankly, a lot of lenders, if they're lending to you and they see that, look, JCPenney's was a big part of your business, they're going to want to know what's your exposure from a preference standpoint.
Bruce, this is Mike.
Yes.
We have a question kind of in this area.
Sure.
We have a viewer who wants to know how long can they look back on these asset purchases?
It's 90 days from the day of the bankruptcy filing, except with regard to insider type transactions that can go back further.
I think, Mike, you said how far can they go back with respect to these asset sales? And so, Bruce, I don't think he's asking about a preference, which is what you answered. It's a fraudulent transfer.
Oh, yeah, which is a very different timeline, if that's the answer, if that's the question, Mike, with regard. And Tom, why don't you cover the fraudulent transfer time period?
4 years. It looks as the bankruptcy code looks to state law, and most states have a 4-year statute on transfers. Some of the statutes are pretty complicated, but let's just say it's quite a long time.
So if you did a transaction 3.5 years ago that's potentially a fraudulent transfer and a bankruptcy gets filed today, that trustee can go back and unwind that transaction.
Now, Bruce, yeah, the world is fraught with risk, and maybe it's going to be a preference, but if a creditor calls you, if a debtor calls you, an account debtor calls you and says, I will pay you 100 cents on the dollar today, do you accept that wire transfer?
Absolutely. You always take the money. You always take the money. You don't say, oh, no, that could be a preference, I'm not going to take it. You always take the money. And then you fight about your defenses to the preference action later.
And so a bird in the bank is worth two in the bush, correct?
Absolutely, absolutely. I want to talk a minute about, let's say you've got an account debtor that owes you money, and let's say it's $1 million, and they're way behind. You've taken appropriate action. You've put them on COD going forward. What do you do about that $1 million? And you may be, the account debtor may be coming to you and saying, look, I can't pay you right now, but here's my plan, here's my business plan, and here's how I can start to pay you. Well, don't just take his word for it. First and foremost, do your own, look at dig into it, make sure that they're sharing financials with you, make sure you're looking at it and seeing, are they paying someone else they shouldn't be paying before they pay me? Are they diverting money somewhere else when they should be paying me? And then also document that forbearance. Let's say, yeah, you've done that, and you say, I'm going to give this guy or this woman or this company some time to work out of this problem. Document it in what we call a forbearance and payment agreement, so that it's very clear on both sides exactly how much was due and owing, what the payment plan is, and at the same time you do this, you make them release any and all other claims or causes of action against you. So they don't come back later when they default under the preference or under the forbearance agreement and say, oh, we've got a claim against you for $2 million. You get them to waive that as part of any forbearance agreement right up front. And if they don't, that's a red flag. Why not? Why aren't, if you think you have claims against me, I want to know them now before I enter into some agreement with you. So you get that up front. And if you can, get collateral. So say you're going to stretch this payment over 3 years, and they're going to pay you over 3 years. Well, is there collateral that they can give you? Maybe it's a second lien on accounts receivable, on inventory, on the property. Look at collateral options. A lot of times in companies that are having difficulty, they've already got a lot of liens on their assets. So that may not be possible, but know that as you go into a forbearance process from that perspective. And quite frankly, it's negotiating that deal, sitting down with them by Zoom and negotiating what are those terms going to be, and really just bullet point them out so everybody's clear. Here's how I expect to be paid, and here's how you've agreed to pay me.
Hey Bruce, I have a suggestion. We're in 47 minutes, and we want to know if there are some questions that people want to ask. But quickly before we do that, I call you up and I say, hey, one of my business partners, a customer or a supplier, filed bankruptcy yesterday. What are the 5 or 6 or 4 or 5, 6 things that you need to tell them that they need to do or can't do as of today?
Very, very good point. Number one, when you have a customer file bankruptcy that owes you money, stop sending the demand letters. Okay, what goes into place, whether you know it or not, is what we term the automatic stay. The automatic stay prevents any creditor from taking any action to collect the debt. So if you continue to send letters, that is a violation of the automatic stay, and you can be penalized from that. I've seen probably some of the early on ones were credit card companies. They would stick you in their system of automatic demand letters and notices for payment, and a consumer files bankruptcy, and those demand notices keep coming. Some of those credit card companies were hit pretty hard with treble damages because they kept sending those letters. So first and foremost, have a process in place where you stop sending those letters. Number two, know the time frame. As of that petition date, there's going to be a date set where you have to file your proof of claim in the bankruptcy case. And some people say, well, if I'm listed on the bankruptcy schedules, do I need to file the claim? I tell clients all the time, I don't care what the schedules say, always, always, always file a proof of claim. And then I tell the client, look, you might as well just write it off right now, and it'll be found money if they pay on the proof of claim, but always file a proof of claim. Now, obviously, if you have a fairly big claim, you're going to be concerned about that. And you are not going to see all of the notices in the bankruptcy case unless you file an entry of appearance. And that's where we're recommending, if you've got a big claim, you need bankruptcy counsel to help you, because bankruptcy cases move very, very quickly, but yet in a lot of ways very slowly. Everything comes before the court on a motion practice. Hearings get set very quickly, and so you've got to stay on top of those, or your rights could really be impacted. And so we tell clients, get bankruptcy counsel, be proactive, get counsel to help you through that claim process, help you file your claim. Watch out for dates. You may want to serve on what's called the Unsecured Creditors Committee. And if you're a creditor and you want to serve on that committee, that gives you a voice at the table in negotiating the plan of how creditors are going to get paid back. If you're not on that committee, a lot of times you're just left out of the loop. So that's something very important to watch. Within 60 days of the filing of the case, there's what's called a 341 meeting. That's the bankruptcy code for what's termed a first meeting of creditors. That's where you get to go ask questions of the debtor, the bankrupt entity, about your claim, about what they're proposing to pay, the likelihood of success. You can dig into everything at those 341 meetings for the most part. And so if you've got a big claim, you're going to want to send somebody to that 341 meeting, your counsel, to ask those questions, to be on top of that. You also, if you think there's shenanigans that have been going on with this company, you can take a deposition in the bankruptcy. It's called a 2004 examination, where you can probe. It's a fishing expedition where you can go in and ask any questions you want of that bankrupt company. So that's another thing that you need to know right up front.
Hey, Bruce and Tom, one thing real quick. So we have about 7 minutes left. I'm not sure exactly what you guys want to cover, but certainly within that 7 minutes, if you could just offer some kind of key takeaways, I think that would really be helpful.
And Mike, let me one question that for a couple of minutes would be very helpful, I think, for Bruce and Tom to weigh in on is we've got companies that are doing a lot of international business. What advice would you have for a company that gets notification that a company that they're working with in a different country is going through bankruptcy or they're failing? And obviously that's country specific. There's different legal frameworks in other different countries. But what would be those first 3 steps? Say it's a company that has some accounts receivable. The company in Taiwan or South Korea or elsewhere writes and says, "Hey, we're failing. We're sorry. We're not going to be able to pay you." Or maybe it's you're sourcing and you've paid a manufacturer in Vietnam, and then they write and say, "Hey, sorry, we're going under. We're not going to deliver, and you can't get your money back."
Those are ugly situations. First and foremost, if you're sending goods and services overseas and you find out that company's filing bankruptcy, do not send any more goods or services unless you get a cashier's check, okay? Or money wired to your account. So stop the bleeding, first and foremost. Now, the second is you need good, competent counsel that knows what they're doing on the ground. And that's where someone like Parsons Behle can help you. Is we've got contacts all over the world where if you're buying goods and services in Taiwan or South Korea or China, we can help with that. Now, like for instance, let's say it's China. That's a tough situation because you really, quite frankly, it's going to be a loss if that company doesn't make it. And if it's goods and service that company absolutely needs, then they're going to come to you and they're going to come with some money and they're going to work something out with you. So you're going to set up maybe some type of retainer situation or escrow where they're paying and they're paying down the old debt as they get new goods and services. So you got to be very proactive on that. Proactive from hiring good counsel on a local basis to help you with the old debt but also good counsel to, but also stopping the bleeding right up front.
And let me emphasize something you said, Bruce, when you said we know people all over the world. We actually do, because you and I and our whole firm and Mike as well, a lot of us are very involved in a group called Terralex. And so I know if I've got a problem in Jakarta, I know there's a law firm that I can call and say, I'm a Terralex member, we need your help on this. I also, and my last comment would be, there are going to be assets for sale, not only in this country, but internationally. And your road to success to solving this supply chain problem may be to buy a factory in Vietnam. Think about that.
Absolutely. I would agree with Tom. There are opportunities from a business perspective during this change here and with COVID, and there's economic opportunities to buy businesses, buy assets, and you ought to look for those opportunities. We see them quite a bit, and there, especially if a company's in bankruptcy, there's opportunities to buy that company out of bankruptcy, and look for those. Get out of that crisis mode and look to the future and future growth. That's the big thing. I mean, we've been in this crisis mode for 6 months, and it's time to move past it and move to, growth.
So Tom Beckett and Bruce White, thank you so much for your expertise today. We appreciate it so very much. And Miles, thanks so much to you and the World Trade Center Utah on behalf of Parsons Behle and Latimer. And I will turn the time over to Miles to close.
Great. Thank you, Mike. Thank you, Bruce and Tom and Jason, for organizing this. Bruce, you said something at the end that I think is very important. It's time to move towards growth, right? We're in the crisis phase. That's one thing that we see. A lot of companies that are coming to World Trade Center Utah, they've figured out how to survive. They've adapted. They've innovated. They've overcome. And now they're thinking through what opportunities are out there. And what I would like to emphasize here, just in closing, is that we have here at World Trade Center Utah many services and grants available to help companies take advantage of the global market disruption that's happened, right? This is a generational event that we've seen in terms of the simultaneous disruption in markets all around the world in such a condensed period of time, which means that it's been challenging, right? I think for all of us, the past 6 months have felt like 6 years. What it also means is that there's opportunity out there. And that's exactly, Tom, that point about, assets for sale internationally is a fantastic one. And so I'd strongly encourage anybody who's listening, live now, and everybody that will watch this later, if you haven't yet, if you're doing anything international whatsoever, please reach out. Help us understand what you're doing, what challenges you're facing, what opportunities you perceive, and we'll have a conversation about the various services that we can provide for free to help you take advantage of those opportunities, as well as talk about who you need to connect with in other markets. And then we can go through our network and our board members and our other partners in other countries to help you connect with the people you need to connect with. And so you can go out there, lean into this crisis in order to find opportunities to growth. That is the solution to the economic challenges we're facing. The extent to which we're successful in doing that here in Utah, the less we'll have need of bankruptcy and some of the expertise that we shared today. And so that's something that we are very eager to do. And this conversation today helps provide really important tools and expertise. They're going to help companies think through their options, either if they're struggling or companies they're working with. But at the end of the day, all of this is with an eye towards moving forward, thinking about growth, and making sure that we are able to recover stronger and better than we were as we came into this crisis. So thank you to the crew that joined us today. Thank you to everybody who participated. And Tom, go for it. You have final word to Tom Beckett.
Thank you.
Thank you very much. Appreciate that. All right, everybody, have a good afternoon.